Let's go across to Ashish Dikshit, who's a lawyer. Flavia Agnes is women rights activist and lawyer herself. Ashish Dikshit, I want to begin with you. While the court has gone back on what the Supreme Court itself said and ordered the Gujarat government to look into the remission of these convicts, today it says it should have been the Maharashtra government. At that time, it was a different order. I understand that. But along with that, the court has made certain, very big observations on the Gujarat government's complicity, quote unquote, and conduct. Don't you think that is an indictment of the Gujarat government's conduct in this case?
See, when these petitioners approached the Supreme Court saying that they should be granted remission, Supreme Court on the basis of a 2010 judgment said that the policy as on the date of the conviction would have to be taken into the consideration. Now what happens is this, that the Supreme Court today says that the offense was tried after it was transferred by the Supreme Court to Maharashtra. Therefore, the policy as applicable in state of Maharashtra would be applicable. So this is a debatable question of law. Therefore, a clarity from the Supreme Court was needed. Because in 2010, in other case, it was held that the policy of the state where the crime has taken place has to be taken into consideration. And that is the basis of criminal law in this country. The jurisdiction of a court arises from the place where the crime is committed. The Supreme Court in this case has transferred the case to Maharashtra, the trial of the case to the Maharashtra, owing and believing that there would be injustice done and that there would be no fair trial. And trial was completed in Gujarat. Trial was completed, sentence was given, upheld by Bombay High Court, upheld by Supreme Court. So as far as that apprehension of Supreme Court, that has gone away. Now, the only concern which these petitioners had, that they have undergone more than 15 years of sentence. And as per the policy of 1992, they said that we are entitled to be released on permission. And the state of Gujarat and the Supreme Court has only said that yes, this policy exists. So whether this amounts to acting in consonance or helping the accused is something which has to be looked from a different perspective, because in my view, when a state comes, the role is very limited because the matter is about remission. There is nothing on the merits of the case.
Yes.
Sentence,
on the merits of the case, I do want to go across to Flavia also. You know, when the remission happened, there was a lot of moral outrage. And of course, because of the seriousness of this case and the crime committed, there was moral outrage and shock over how these rapists, convicted rapists and murderers can be released early. But if you look at the order of the Supreme Court, even today, barring that technicality that Gujarat government was not the competent authority and it was Maharashtra government, they've not made any moral judgment on the remission itself. The remission, they have not really barred or declared illegal, but for the fact that we could argue that the process was not correct.
But that is important as per the CRPC. Section 432, the competent court was the court in Maharashtra and not in Gujarat. And that has been the main concern of the Supreme Court in this case. I agree with you, they have not said about the remission itself because the technicality itself is wrong. So they have set aside the order. So the question of whether they were entitled for remission or not did not come up. And it was at this stage of examining the technicalities and the procedures. And the Supreme Court has come out very strongly against the Gujarat government, saying that not all the facts were
put in front of the court, yes.
And there was complacency on the part of the government. They colluded with the 11 convicts and they obtained this order. And then they gave the remission. This is the main flaw of the order itself. And they have stayed on this technicality. It is yet to be seen whether the remission itself was legal or not legal.
No, but this is why I asked you that question, Flavia, because at the time, the outrage was moral. It was not legal. At the time, the outrage was, look, this is happening in Gujarat. Look, what are they doing to the minority, woman victim in this case that transpired during the Gujarat riots. It was a lot of morality, imposed on legality. Was that also wrong to jump the gun and, create this outrage that somehow this is happening only because the victim is a Muslim woman and the perpetrators were Hindu in a communal riot? Because that was the tone of the opposition today, opposition at that time, including many people asking, how can you do remission, give remission to such convicts?
We have not yet come to that stage as far as the Supreme Court is concerned. We are still at the stage of examining the procedure under the CRPC and technicalities of the particular order. And here the Supreme Court has made very clear that the Gujarat government was complicit and they colluded with the 11 convicts and they gave the remission. So now that has to be first of all seen into. Then the question comes whether this was, whether there's this, the moral outrage was just and whether they were entitled for remission at all. So that is the second question that is coming up. And that's a very right question. And according to me, they were not entitled. So
you firmly still believe that there was a problem in the decision itself, not just the government that made the decision. And in this case particularly, if you could argue, why do you feel these convicts don't deserve remission?
Because the crime was so heinous. The Mumbai court, Sessions Court, as well as all the superior courts have upheld this. And they have given this conviction for entire life. Not only for 14 years as it is made out. And the accused convicts went to court saying we have finished 14 years. So now please remit it. And they went to Supreme Court and one person went and all of them were given remission. And according to me, the moral outrage was that how can one person goes, how can all 11 get a remission? But Supreme Court now concentrated on the technicality and set aside. Now we have to see whether they will approach the Maharashtra court and what the Maharashtra court will decide.